Okay, page 56. So we're going to finish up today talking about intentional torts, and then we'll switch over to negligence. So last time, if I remember, we left off right here. So the next intentional tort is malicious prosecution. This is basically where somebody initiates a criminal case without an with an improper purpose, without probable cause, and is essentially either filing a false police report or initiating a wrongful prosecution in the criminal system. Now, that would also be a crime. Filing a false police report is a crime, but this is a form of an intentional tort. This can also apply in a situation where you have a law enforcement officer or a prosecutor or somebody else involved in the criminal justice system that initiates a false case. I actually had a situation once where there was a sheriff's deputy that was going through a divorce, and as part of the whole scenario, the sheriff's deputy made up a whole bunch of false claims against the new significant other of their former spouse, and they got arrested for that eventually. But it turned out that that was all false, and so that was a form of malicious prosecution. It is utilizing the criminal justice system for an improper purpose. Now, there's a similar tort on the next page, right here, and that is the intentional tort of abuse of process. Pull that so it shows on my screen. Abuse of process. Now, this will depend on what state you're in. This may also apply to criminal, but typically when we refer to abuse of process, it is referring to the civil system. And this would be a situation where somebody is utilizing, basically filing frivolous lawsuits that don't really have any meritorious basis against another person. So maybe, for example, I have a neighbor that I don't like, and so like every 2 days I go down and I file a small claims court case against my neighbor. So like one day I file a case against them because they left their porch light on. And then the next day I file a civil lawsuit against them because they parked their car sideways in their own driveway. And the next day I sue them because they didn't mow their lawn last week or something like that. And so essentially I'm doing that because I want to harass them through the legal system. And so that's a situation where, if I sue somebody and they don't go down and file an answer of response, they're going to lose by default. So now it's putting the person in this position where they've got to defend against these frivolous lawsuits. So what they could then do is file a counterclaim back against me for abuse of process. Or another type of scenario where you'll see this sometimes is when you have like a whistleblower or somebody that's testifying against maybe a development, and the company that's doing the development files a lawsuit against the person that's testifying against what they want to do, like maybe build a shopping mall or something. And so they'll sue them for libel, slander, as a nuisance suit. And basically they're just trying to get the person to be quiet. So that could be a form of abuse of process as well. And that's basically utilizing the civil court system. That's primarily where this applies. For an improper purpose, or a frivolous type of a lawsuit. All right. The next intentional tort is the intentional tort of, goes by different names depending on what state you're in, deceit, fraud, or misrepresentation is what we call here primarily in Oregon. And again, this could also be a crime. And this is basically lying. And the idea here is that you see this most of the time in somebody that's selling something, either a house or a car or whatever the case may be. And as part of the sale process, they lie about a material issue. So maybe you're buying my house and I tell you that the roof does not leak when in fact it's horrible and it needs a whole new roof and it's all rotted out. and I know that, but I'm lying to you because I don't want to have to put a new roof on. So you buy the house, you find out that I've been lying the whole time, and so you would sue me then for misrepresentation. And then basically you would ask the court to either require me to give you your money back or to pay for the repairs necessary to bring the house up to the standard that I represented it was in, or the diminished value of the house. There are different potential remedies there. This might also apply in a situation where I was selling a car, if I lied about the condition of the car, or that kind of thing. Now oftentimes, sometimes you'll see the phrase "as is," and this is a phrase that's pretty common, and this refers to essentially a notification by the party that's selling, like a car or real estate or whatever, that no representations are being made. It's up to the buyer to determine the quality or condition of the vehicle or the real estate or whatever. And that can provide a defense to a claim of misrepresentation. However, if you're going to do that, you've got to be careful, because if you say you're selling something as is, you can't then turn around and also say, well, it's in perfect condition, I had it checked out by a mechanic, and basically lie. So that phrase "as is" not an absolute defense to that claim of misrepresentation. Now, the other interesting thing about this is we are now seeing, primarily historically, you had to prove that the person made a false statement about the condition of the vehicle or the house or whatever. But now we're seeing another area of growth in the law where, especially in real estate, for residential real estate, where you have a duty to disclose. That is, if you know that the house has a leaky roof, or the foundation is crumbling, or there's some other material problem, then you may have, by law, a duty to disclose that condition. In other words, you can't just be silent. You have to actually say, hey, there's a problem with the roof. You have to be upfront about it. And that's quite a bit different than historically, where essentially, if you kept your mouth shut, you were fine. So the idea now, and this is here in Oregon, for example, if you're selling residential real estate, you have to provide a seller's disclosure statement where you go through and you check the box, the condition of the roof, is it hooked up to the sewer, is it on city water, have there been any flooding problems, and you have to say yes or no on a form. It's a standardized form. And so that's a form of failure to disclose type of a misrepresentation. Also, if you're a real estate agent in Oregon, you have an obligation as part of your licensing to disclose known material problems in the property that you're selling. And so that's sort of a trend that we're seeing now. And again, that's going to be established by some legal rule in whatever state you're in. So either making an overt false statement, or in some cases, being quiet and not disclosing a known problem could lead to this type of a tort. All right, next we have trespassing. Trespassing is defined as entering or remaining on somebody's property without legal justification or right to be there. Or it could also be causing somebody else to enter. Like, for example, if I tell you, you have permission to go over to my friend's house because I left my books there, and I'm lying to you, and therefore, based on the reliance on what I told you, you go trespass. So you could make the argument that I caused you to enter. Or it could be a situation where I have failure to remove if I place something on your property, or if I've invaded your airspace. So maybe I have, like, my dog goes potty on your front lawn and I don't clean it up. That's a form of trespassing, right? So what I want you to remember about trespassing is it requires a physical invasion. There must be a physical invasion of the property by either placing something there or going onto the property invading the airspace in some way, maybe like with a drone or something. A physical invasion. Now there's a similar tort to trespassing, which is called a nuisance, right here. Nuisance. And I want you to be able to differentiate between a trespass and a nuisance. A nuisance is when somebody is engaging in some sort of intentional conduct that has an interference or with people's property. So it's a non-physical invasion. So this would be something like if I was playing music really loud all the time, all night long, and it was causing noise, unreasonable amount of noise, and you're my neighbor, that could be defined as a nuisance. Or it could be a situation where I was doing something like maybe cooking meth in my meth lab, and the smell's coming over onto your property. So it's not really a physical invasion, it's an odor or a loud noise, or perhaps I've got really extremely bright lights that I'm pointing at your house and it's lighting up your whole house all night long or something like that. So a non-physical type of interference with property. So the difference between the two, trespassing would be a physical invasion, and a nuisance would be a non-physical interference with property. All right, so how about if I'm spraying Roundup? You guys know what Roundup is, glyphosate, it's a weed killer. So I'm spraying Roundup and it drifts over onto your rose bushes on your yard and kills your roses. Would that be a trespass or a nuisance?
Nuisance.
It seems like it'd be a nuisance, right? But that's actually a physical invasion.
Really?
So yeah, it would be a trespass. The particles.
Oh.
Yeah, the particles of the, so we actually have a law in Oregon that if you damage somebody's timber, like if you cut down a tree that's not yours, you can actually sue the person for 3 times the damages. Roundup cases are actually pretty common. Not necessarily Roundup, but it could be 2,4-D or other type of chemicals. So the difference is physical invasion versus non-physical. So if you know that much, that's kind of what I'm getting at. All right, and then finally, or not finally, but next we have conversion. Conversion is essentially the civil tort equivalent of a theft or destruction of property, which is called a criminal mischief under Oregon criminal law. So essentially conversion is taking somebody's property, stealing it, failure to give property back. So if I borrowed your chainsaw and I never gave it back to you, I've now committed the tort of conversion and also potentially a criminal theft. Or it could be damaging or destroying your property, or any other interference with property that you have. It could be maybe a bank, you close your account and they don't give you your money back. They don't have any legal justification to hold your money, or something like that. So basically acquiring, removing, transferring, withholding, destroying, damaging, using without permission, anything like that is considered a conversion, and that can lead to a civil lawsuit as an intentional tort. And again, it's sort of the civil equivalent of theft. And then finally, the last one here, letter M, is for intentional torts, the tort of wrongful death. Wrongful death is when somebody has either intent, well, it can be intentionally or negligently as well. Basically done something that led to or was a substantial factor in somebody dying. Now most commonly you'll see wrongful death cases in like an automobile accident where somebody ran over somebody either on purpose or negligently and the person died, and therefore the family, the estate can sue for wrongful death. So it's sort of the civil equivalent of homicide. Now it may be intentional, or it may be reckless, or it may be negligent. There are different levels of wrongful death, but essentially it is the civil equivalent of either a homicide or a manslaughter or something like that. Okay, so that's it for intentional torts. Just as a reminder, on page 56 for the midterm, this is essentially 100%. I ask this every time. What are 6 types of intentional torts? Now, just remember, all of these torts on page 56 and 57 are all intentional. And what that means is there is an obligation when you file a lawsuit to be able to prove that the person that committed the wrongful act did so purposefully with the intent to either cause the outcome or to cause the activity that led to the outcome. So there is a requirement of intentional conduct. Now that's very important to understand because the next type of tort we're going to talk about is negligence, which is unintentional. And so if I ask you, name 6 types of intentional torts, negligence is not a correct answer because it's unintentional. And we're going to get to negligence in a little bit. So for the midterm, be able to list out 6 of these. I also want you to be able to, I give you like a little fact pattern, you know, like Bill hit Ted in the head with a bed, that was painted red. That's bad. What kind of tort might that be? So that would be a battery, something like that, okay? So I want you to be able to pick and choose the different tort that might apply. And if I do ask you a question like that, just be aware that there may be more than one tort involved. There may be an assault and a battery. There may be defamation and invasion of privacy. There may be a nuisance and a trespass. They're not mutually exclusive. So I want you to be able to pick out which torts might apply. All right, so that is the end of that section.